Welcome back to The Takeout. Sources tell CBS News the Justice Department has opened a criminal investigation into a nonprofit that funded part of E. Jean Carroll's civil litigation against President Donald Trump. Carroll won 2 lawsuits against Trump, accusing him of sexual assault and defamation. She says he attacked her in a department store dressing room in the mid-1990s. Trump has denied the allegations, but both judgments were upheld on federal appeal. CBS News legal contributor Jessica Levinson joins me now. So let's start with the fact that these judgments were upheld. So what would the basis of revisiting this particular part of a potential perjury allegation against E. Jean Carroll be relevant to?
Oh, I love this question because the answer is that it would not unwind the verdicts that we see. So what we're looking at here apparently are investigations into potential perjury by E. Jean Carroll, and we can talk about why I think that's a weak case, and then also into the nonprofit that helped to defray the costs of this case. But I think what's important for people to know, and your question tees this up perfectly, is that even if there was perjury, even if there was an issue with the funding by the nonprofit, that doesn't undermine the substance of the claims that E. Jean Carroll brought, and it doesn't unwind the jury's verdict in this case. I think when it comes to the questions that the Trump administration asked about the source of funding, what they were trying to get at is E. Jean Carroll's credibility and why are you really bringing this case? But the jury found that, in fact, there was a there, and that these claims were meritorious, and any potential perjury charge and an investigation to the nonprofit, I see as separate and apart from those jury verdicts.
Why is it a weak case about possible perjury?
So I think it's a weak case for a couple of reasons. The idea is that the case is based on a 2022 deposition in which E. Jean Carroll said that she did not think that there was or there wasn't outside funding for her case. Later, she and her attorney corrected the record and said, in fact, that there was outside funding. They flagged that correction for the trial court judge. The trial court judge found that, in fact, she was credible in correcting the record. And I believe in the case said that President Trump's attorneys should not ask about that particular issue because, again, the judge found there wasn't an issue with her credibility. This issue, in part, went up to the Court of Appeals, the Second Circuit. The Second Circuit looked at this and similarly found that E. Jean Carroll had credibly said, I just forgot in 2022, and that she corrected the record and that this, in fact, did not undermine her credibility in bringing those claims. The other thing I would add, so again, you have 2 sets of judges, the district court judge and then the Court of Appeals judges looking at this issue. I'd also add it's extremely unusual to have the Department of Justice look into alleged perjury based on a deposition in a case between 2 private parties.
Jessica Levinson, always great stuff. Thank you very much.